Justice Jackson?
So you've had a couple questions about what good is a hearing? What would a hearing do in the situation where Ms. Cook has made a statement through her lawyer about the allegations? I guess I'm wondering, setting aside for a moment the standards for cause, don't we have to have a circumstance in this kind of situation in which the facts are established? In other words, I thought the work of the hearing, even in this situation, would be to establish when these applications were signed, what she thought she was attesting to, what actually was going on with respect to these documents that the president is pointing to that says, and he says they establish her deceit and gross negligence or whatnot. And I think before we even get there, we have to know what the facts are related to this. Isn't that what the hearing would be about, at least in part?
I think it would be, and maybe though to try to defend my, heads I win, tails you lose answer to Justice Alito, I mean, you could think about this by analogy. I mean, there's certain circumstances where you essentially grant a motion to dismiss for one side. You basically say, look, we didn't have a hearing here, that was a mistake, but even on sort of the best reading of the evidence, this is at most an inadvertent mistake, and so there is no for-cause removal, in which case my client would win. On the other hand, if, normally you have that kind of evidentiary hearing, and that is to establish sort of the facts, and then you then apply the law to those facts that have been established. But there are circumstances where you sort of don't need any more facts.
But then you're in Justice Kavanaugh's world, which is you would still at the hearing then go to the legal question of whether or not what you agree happened here counts as gross negligence. You would say it has to be at least that in order to satisfy the for-cause standard. The other side would say no. So there's some work to be done in a hearing.
Absolutely. And another way of putting it is, look, the denial of the hearing to my client, if she does indeed have a right to a hearing, cannot be harmless error. Like, it just can't, no matter what you think of the facts. On the other hand, if you agree with us on the law, you could still resolve this case in her favor on the grounds that, there were two mistakes here. One, she didn't get a hearing, but we don't have to remand for a hearing or any of the rest, because even on the facts kind of most, in the light most favorable to the government, this isn't a removable offense.
Can I go quickly to the standards? Because as I read the sort of what happened here, it wasn't as though the district court just sort of made it up in terms of what she thought should count as for cause. My understanding is that she was looking, as you've said several times, to the common law and what courts have traditionally said. And I see, for example, a Maryland court, Board of State Commissioners of Hagerstown, in 1903, which is around the same time as the establishment of this statute, that said, quote, "The phrase for cause must mean some cause affecting the ability or fitness of the incumbent to perform the duty imposed upon him." And other similar courts at the time talked about pre-tenure conduct and said if it was pre-tenure, it can't be sufficient cause unless it was serious enough to undermine the job performance. A mere allegation was not enough back at common law. It had to have been tested and proven, like through a conviction. So these standards that were used here to determine, at least at the district court level, whether cause was satisfied came from somewhere. Is that right?
Absolutely. And, I love that Hagerstown case because not only is it a very helpful common law case, but it's actually the basis for the definition in Black's law that the government and Judge Katsas below relied on. I mean, Black's law is an unusual dictionary. It just doesn't sort of, pop out the meaning from Noah Webster's mind. It cites cases for particular concepts. And the case it cites for cause is that Hagerstown case.
And so all the hypotheticals, I mean, we see them and they might be problematic, but they would be tested against the standards that the courts have applied, right?
Absolutely. And if I could just elaborate in one respect, I mean, if you think about pre-office conduct, there's only two kinds. One, there is pre-office conduct that was disclosed to the Senate in the confirmation process. And as to that, even the government sort of says, well, you probably shouldn't let the next president sort of relitigate all of that. And then the second kind is stuff that was undisclosed. And if it's as serious as we're talking about, that's essentially the nominee, defrauding the Senate. And so I actually think in that respect, impeachment is probably a more fit remedy than it might be in some other circumstance, because you're going to have whatever the conduct is, plus you're going to have the Senate being pretty darn vexed that was withheld from them in the confirmation
Final
process.
question. I took you to be conceding that there was notice here, and I guess I'm a little concerned about that. I mean, are you conceding that a posting on social media is sufficient notice in a situation like this when the president is seeking to remove a governor for cause?
So what I would say is, I think...
I know it happened. She got notice. We live in a world that is connected, but I guess isn't notice a particular thing in the common law?
Well,
put
it this way. I don't sort of resist the idea that the Truth Social post is notice, because I think it's also fundamentally defective notice, because it's also indisputable evidence that the president prejudged the matter. And
right,
so it's not the kind of notice.
So hypothesize he didn't say you are fired or you should be fired. Hypothesize he just said, I have this information and I intend to fire the governor. Why wouldn't he have to send the letter to her? How is it that we can assume that she's on social media or has looked at the news, or that that's sufficient notice even if she did turn on the news and he's saying that? I don't know why that would be enough.
Look, I might make that argument, but that doesn't seem, if he said on Truth Social that, look, here, I have this allegation and I'm going to convene a hearing at the Roosevelt Room at 4 p.m. tomorrow. Please bring all your evidence.
What if she doesn't have a Truth Social account? She doesn't show up. Is that enough notice?
I think under those circumstances, probably not. But I think as a practical matter, in most circumstances, the president puts it on Truth Social. Most people, most of the time, are going to consider that to be notice. Again, part of the reason I'm not resisting is, or I'm sort of moderating this, is because this notice isn't the kind of notice the common law envisioned, because the common law would envision notice that didn't prejudge the matter.
Thank you.
Thank you, counsel.